Dr. Shikhar, you may start the session.
Please switch on the cameras, everyone. We'll start.
Dr. Shikhar, you may start the session.
Good afternoon and welcome to our 16th webinar in the series of India's Azadi Ka Amrit Mahotsav and 80 years of CSIR. As we all know, our nation is celebrating its 75 years of independence and Council of Scientific and Industrial Research. CSIR. I am starting now. Okay. Good afternoon, everyone, and welcome to our 16th webinar in the series of India's Azadi Ka Amrit Mahotsav and 80 years of CSIR. As we all know, our nation is celebrating its 75 years of independence, and Council of Scientific and Industrial Research, CSIR, is celebrating its 80 years of profound service to the nation. CSIR, Center for Cellular and Molecular Biology, CCMB, Hyderabad, is a premier research organization in frontier areas of modern biology, performing high-quality basic research, training, and promoting centralized national facilities for the new and modern techniques in interdisciplinary areas of biology. Today's talk is an achievement and an exciting success story from CSIR CCMB on DNA fingerprinting technology, its success and future. The very well-known scientist Padma Shri late Dr. Lalji Singh, also famously called as the father of Indian DNA fingerprinting, belonged to this laboratory and served as its former director. The scientists from CSIR CCMB worked extensively in the field of DNA fingerprinting technology in India and also conceptualized specialized laboratory in the area, the Center for DNA Fingerprinting and Diagnostics, CDFD. The technology of DNA fingerprinting has aided the Indian judicial system in solving cases using the genetic markers identifying the individual. So today we have experts who will further take us through the journey of DNA fingerprinting technology in India and in CSIR and its adoption in the Indian judicial system. We have with us Director CSIR CCMB Dr. Vinay Nandikuri, Dr. K. Thangaraj, Chief Scientist CSIR CCMB and Director Center for DNA Fingerprinting and Diagnostics, Hyderabad, Dr. G.K. Goswami, Honorary Professor, National Law University, Delhi, and Dr. K.V.K. Shanti, Professor, Nalsa University of Law, Hyderabad. I am Dr. Shikha with you once again, scientist from Science Communication Directorate at CSIR headquarters, and I welcome you all in the webinar today. So before we begin with our today's talk, I request Dr. Vinay Nandikuri, who is a well-known molecular biologist and has been a scientist at National Institute of Immunology, New Delhi, and has recently taken the charge as Director CCMB, to kindly deliver the opening remarks for the session and welcome our participants and the audience. So over to you, Dr. Vinay Nandikuri.
Thank you. It's a pleasure to give introduction for this particular seminar on DNA fingerprinting, and there is no person better than Thangaraj to give a talk from CCMB. I also welcome the other participants, speakers, Dr. Goswami and Dr. Shanti. And thank you, Shikha, for the introduction. DNA fingerprinting, as all of us know, is an extremely important tool for solving the crimes. The introduction. But, the origin of it is not exactly something that started with humans. This has come from the satellite DNA of an Indian poisonous snake. The probes for this originally came from that. And this technique is followed of a basic research on molecular basis of sex determination to understand what makes a man man and a woman woman. So that's where it started out. And 1988 was the first time CCMB scientists have developed indigenous probes for DNA fingerprinting. The interesting aspect is that India was the third country in the world at that point of time to develop its own DNA fingerprinting probe, which is an amazing achievement in itself. And if you really want to think about what and all has happened, this DNA fingerprinting has been used extensively by Indian judiciary to solve multiple crimes and multiple aspects. It has been used. Rape cases, murder cases, including the assassination of late Prime Minister Shri Rajiv Gandhi ji, Punjab Chief Ministers, and other famous Tandoor case. You may be aware of all these things that came in the news. The origin of it, the DNA fingerprinting was used extensively for all these cases. And we are proud that it has actually started off in Center for Cellular and Molecular Biology in Hyderabad. Now, after that, CDFD became a different institute and it's continuing the work. But we are very happy that the whole process started at CCMB way back in 1988. Without actually taking any further time, I would request our speakers and other people to take over. I just want to say that Dr. Thangaraj has been a pillar of this for a while. He has moved into many other areas. He's one of those initial founders of this too. So I'm glad he's the one who's going to speak now, and obviously others too. Thank you, everybody. Thank you very much. I hope to see a good set of talks now, or hear good set of talks now.
Thank you very much, sir, for the welcome and giving us a brief overview of DNA fingerprinting technology and how it came into existence. So in order to know more about this technology, the present and future of its legal uses as well, we shall move to our speakers connected with us today. So the first speaker for the webinar is Dr. K. Thangaraj, Chief Scientist and Group Leader, Evolutionary and Medical Genetics Laboratory at CSIR CCMB, and also the Director of Center for DNA Fingerprinting and Diagnostics. Dr. Thangaraj is an expert in basically two broad areas of human genetics. First is population genetics and the medical genetics. So he has various significant contributions in both the areas in the form of research on origin and affinities of Indian population, contribution to global population genomics, tracing the origin of skeletal remains of mysterious Roopkund Lake, genetic basis of cardiovascular disease, and various others. So these are some of the highlighted publications in Nature journals. So Dr. Thangaraj has also several awards in his name. Some of them are Sun Pharma Research Award in the field of medical sciences, Raman Research Fellowship, and the Rashtriya Ratan Award. So with this brief intro, I invite Dr. Thangaraj to kindly inform us more about the development of the DNA fingerprinting technology at CSIR CCMB and its ongoing and envisaged application. So over to you, Dr. Thangaraj.
Thank you, Dr. Shika, and also I welcome the panelists, including Dr. Vinay, Dr. Goswami, and Dr. Shanti. I think it's an important event because this is one of the technology which has seen multiple applications, particularly solving crime in many cases, which I will highlight some of them. Without wasting much of time, I'll right away try to share my slides. The slide is visible with full screen?
The slide is visible, but not in full screen.
Okay. But I could see full screen. Maybe I'll stop, reshare. If we don't see, then I'll continue with this.
Okay.
Could you see the full screen now?
So not in full screen. Slides have come. It's
Okay.
visible.
Is the slide sufficiently visible?
Uh,
Go ahead.
Yes, sir, it's visible, but you can maximize it also.
Yeah, little maximization will help.
It's visible, sir.
Okay. 1 second. Is it sufficiently seen
It's not visible.
now?
The slides are not visible to me.
Okay.
Dr. Thangraj, first I think you maximize it and then share with the audience.
I tried that. Is it okay now?
Sir, it's okay. It's not in full screen mode,
Right.
but it's visible. It's visible.
Yeah, but I could see. But anyway, without wasting time, I start
Please
with you.
continue.
Okay. Yeah. So good evening to all of you. It's my pleasure to talk about how the DNA fingerprinting has been developed in CCMB, CSIR as a whole, and how the journey of this technique has gone and what is the present status. Most of you are aware this technique was initially developed by Sir Alec Jeffrey in UK when he was doing his basic research and found that the class of repeats could give individual specific profile. And it was a surprise to him to find that the class of repeat gives a individual specific banding pattern. And before that, before even it was identified, Dr. Lalji Singh in CCMB was working on evolution of sex chromosomes in snakes. In snakes, there are 3 different kind of snakes. One is a primitive snakes, another one is intermediate, and this is a very highly evolved snakes. And in case of primitive snake, we don't see any difference between the 6 chromosomes like what we have in human, X and Y. In snake, it's WZ. So W is the one which determines the sex of the snake. We don't see any difference. Unlike human, if you take X chromosome is long and Y chromosome is very short. But in case of intermediate snake, the sizes remain the same, we don't find, but actually it accumulated a class of repeat called the GATA. In highly evolved snake, even you can see the difference between Z and W chromosome. And this is one of his interesting finding, and he has done a lot more work on this. And they identified this particular repeat called as banded kite mini satellite repeat, where you see there's a stretch of repeats as GATA repeating for many times. And that time, Professor...
Sorry to interrupt, sir. The slides are not moving.
Was not moving. Okay, maybe I'll...
Yeah, now.
now?
Yeah, it has gone to the next slide now.
Yeah, so I'll show this slide. I talked about the slide. These are the 3 different kind of snakes. Okay. This is a primitive snake, intermediate, and highly evolved snake. In case of primitive snake, we don't see the difference between the 6 chromosomes. In case of human, we have X and Y, here W and Z. We don't see any difference. But in case of intermediate snake, we don't see the lengthwise difference, but you see there's a molecular level, there is an accumulation of GATA repeat that was done by in situ hybridization. In case of highly evolved snake, you can see the size difference between Z and W chromosome, and also you can see the accumulation of GATA repeat, which was shown by in situ hybridization. There's a dark spots. And he isolated that repeat, and you can see the sequence of that banded kite mini satellite repeats, GATA. And that was a time Dr. Bhargava, then the director of CCMB, encouraged Dr. Lalji Singh to try to hybridize this repeat on the human DNA and see how it gives, whether it is giving a banding pattern like individual banding pattern as Alex Jeffrey observed or not. And before this itself, he has published this work in highly well-reputed journals like Cell, that the BKM sequence are essential for sex determination in snakes, and many other papers which I could not put on the slide. Then when we try to hybridize on the human DNA, and in fact, you could see the individual specific banding pattern. So that's the first time he has hybridized on the human DNA and found there is an individual specific banding pattern. And he took this technique to users, particularly the very first case which I wanted to highlight here. This case actually comes from Kerala. There's a place called Telcheri, and he's a building contractor, and he promised to marry this lady, but by then she became pregnant and the child was born. Then he refused to marry her, saying that the child is not him, belongs to him. So you remember, this was long back, more than 2.5 decades. And this lady could read about the technique and approached CCMB to do DNA fingerprinting to prove that he is the father of the child. And this is how it has been established. And this is the very first case which has been accepted in the court of law. Then subsequently, there are several important cases. Some of them Dr. Vinay already highlighted, but still I would like to show that so this is the case of the late Prime Minister Sri Rajiv Gandhi, which when he was traveling, and there's a place called Sri Perumbudur near Chennai. That's where this assassination took place. There's a lady called Tanu who had a bomb in her belt. This is a tissue which was sticking on the belt, and you can see her body was reconstructed. And her parents' sample have been collected, and DNA was isolated from this tissue, and was confirmed that she is Tanu, and who was the one who carried the bomb in her belt. There are several other cases which are associated with this. The person who was the mastermind of this overall assassination, Sivarasan, he basically from Sri Lanka, and he has been shot dead in Bangalore. Again, his parents' samples have been brought from Sri Lanka, and his identity was confirmed. So the person who inaugurated CCMB, Dr. Rajiv Gandhi, and unfortunately has to his life has to end like this, and whose identity and the people who are behind his assassination has been identified. Then this is another case where the Swamiji, one of the Swamiji, Premananda, who also from Sri Lanka, who had an ashramam in a place called Pudukkottai in Tamil Nadu. And he had a lot of ladies in the ashramam. One lady escaped from there when she was pregnant. She approached the police, and there was abortion of the fetus, and the whole fetus was sent to us, and we established the identity of the child, and it's been proven that Premananda is the father of that fetus, and based on that, and double imprisonment has been given to him in the court. There's also another case which again when I mentioned about Tandoor murder case, where this is very important in two aspects, and so far which I showed where the multi-locus probe, where you could see multiple bands, and this is a single locus probe for the first time developed and used here, where you can see, because this is locus specific, there are two allele, one chromosome comes from the father, one from the mother, so we'll get two different allele, and this has been established using both multi-locus probe and single locus probe for this particular case. So another important thing is this is a time the Clausing was negotiating with the government, and the DBT in fact come forward to set up the institute called Center for DNA Fingerprinting and Technology and Diagnostics. So in both aspects, this is one of the important case to develop single locus probe and also to initiate a new institute called Center for DNA Fingerprinting and Diagnostics. And if you look at overall how this technique has helped, this technique has helped in solving crimes. This technique has helped in using very high quality publications, and also it helps in starting a new institute. So this is an institute which is of now 25-year-old. Just we are celebrating the silver jubilee of this particular institute. You can imagine that there's a separate institute set up based on this technology, and we have about 20 different groups working on various areas, and the mandate of the institute is providing DNA fingerprinting service. And in this process, we also conducted large number of training courses initially at CCMB for most of the forensic laboratory where they could go and set up DNA fingerprinting labs. And in addition to that, there are several other institutes, including ICR institutes, have come forward for the training, and they have set up the lab for barcoding some of the animals and plant species. So if you look at overall impact of this technology, it has helped in crime, it has helped in new institute, it has helped in developing new technology, and also helped in high quality research publications. So I think within the short period, this is what I could do. I thank CSIR for taking this initiative, and I'm indeed happy for giving this kind of overview and telling about the history of the DNA fingerprint technology. Thank you very much.
Thank you very much, Dr. Thangaraj, for such an informative talk, showing us the key cases in which DNA fingerprinting acted as a player in solving the crimes or identifying the individual. So thank you once again. We will move to our next speaker, Dr. G.K. Goswami, Honorary Professor in the National Law University, Delhi. Dr. Goswami holds MSc, LLB, PhD in Medicinal Chemistry, and another PhD in Law, and then DSc in Forensic Sciences and Law, and is 1997 batch IPS officer of UP cadre. In 2020, he joined as the Chief of Anti-Terror Squad, ATS, of the state of Uttar Pradesh, after serving for more than 7 years on deputation to the Government of India in various capacities. Some of them are Joint Director, Anti-Corruption, Headquarters Zone, Lucknow Zone of Central Bureau of Investigation, and Director, CBI Academy, Ghaziabad. Dr. Goswami has been honored with second bar by the Honorable President of India by decorating him 3 times with the Police Medal of Gallantry, the highest national award for police. He has also been awarded the Police Medal for Meritorious Service and the Gold Medal for Gallantry. So with this short intro, I invite Dr. Goswami to kindly share some information and experience on law to incorporate DNA fingerprinting evidence in the courtroom. Over to you, Dr. Goswami.
Thank you, Dr. Sikha. Indeed, it is a great pleasure for me to associate and to share my views on this August gathering, and particularly I am thankful to invite by the Director CCMB as Dr. Thangraj must be aware, and he must be remembering my association with Dr. Lalji Singh long back, about I think now about 12 years back. I was there and we met in the room of Dr. Lalji Singh. And I was again fortunate that he supervised me in my PhD when I did on law, and particularly the topic was how sexual offense can be dealt by use of DNA. So I had great association, and I fondly remember his simplicity, humility, his scientific acumen, and his untimely death was really very shocking for all of us. With my heartfelt gratitude to Professor Lalji Singh, I start with my talk, and I know the limitation of time, but in the beginning itself, I must say that a lot of things have been told by Dr. Thangraj, because I was little worried that in 10 minutes, 12 minutes time, how to concise a very long journey of a very big tool like DNA, which has proved its credence in courtroom and in various aspects of judicial system. So I will just begin without taking much of time. I will rush through many slides, but I will touch only those areas where I will feel that, yes, I must speak a bit, and then I will try to complete within the stipulated time. So I will touch actually the emergence. I think a lot of things have been already discussed, so I will not go for. Everybody knows that DNA helps for guilt, proving guilt as well as innocence. And DNA is not only used for the criminal adjudication, but also civil disputes, particularly paternity determination, property disputes, many more. More so, the jurisprudential perspective, if we talk about the self-incrimination, how it is relevant, and how privacy basically is very important, particularly in the domain of Aadhaar case, Justice Puttaswamy case, particularly in 2018. Although all these things I will not be able to cover within this limited time, but you as scientists must be aware that forensic science is not a pure science, it is amalgamation of science with law. So until unless the forensic scientists understand the fine nuances of law, I think they may not be very much, understanding the court work. I don't expect that a forensic scientist must be a lawyer, but they should have some understanding that how court looks towards the DNA as evidence. It is not merely a science tool, it is a legal tool basically. And then of course, I will give one example or so, some example about the forensic fraud, particularly DNA fraud. So DNA per se is a very good tool, but if it comes in the hands of a person who has the malice, then it can be misused also, and it can create havoc also. So we have to be very, very cautious when we use it. So before I enter into this domain, basically my last research did in National Forensic Science University. This has proved very importantly the role of DNA in two ways. You see, I generally talk that if you see the statistics of rape cases, normally the conviction rate is about 30%, but charge sheets are being filed in nearly 90% cases. So 60% cases fail in the courtroom because of the lack of evidence or the quality of evidence. So DNA prove very good help actually in body offense, particularly sexual offense. And my research says that if you do DNA, if you find that DNA is positive report and 164 statement, that is courtroom statement, as well as medical legal positive report, you will get 100% conviction rate. So DNA has very important role in basically sexual offense as well as other body offense. Another finding is also very pertinent, which establishes empirically that DNA also reduce the trial time. My research says, particularly in POCSO cases, that nearly half time had been reduced. Say if in case normally where DNA is not there, if it takes 2 years, in those cases where DNA was there, it reduced to half. So this is the beauty of DNA as far as the trial proceedings are concerned. Now, quickly, I will go to its genesis, and I think everybody knows about it. But I will tell you the story actually. What is the story and what are the learning points in the beginning itself? Everybody knows how DNA came into courtroom. Alex Jeffrey is the father of DNA fingerprinting. Basically, two adolescent girls, they were being raped in 1983 and 1986. And the place of occurrence for both the incidents were almost a stone throw distance. It was hardly 50-40 meters. So those were the cold cases, and Alex Jeffrey helped it. A lot of story can be told with this, but I reduce my talk to this point that when these were the cold cases, the detection was difficult. One fellow was caught, Richard Buckland. At that time, his age was about 18 years. He was having some speech, some limitation of speech. He actually admitted to commit crime of 1986, but somehow it was not accepted by court, and then help of DNA was taken, and it established that Colin Pitchfork was the real culprit. Right here, the learning point is that DNA from its first case itself not only established guilt, but it also established innocence of Richard Buckland. My take here is that, my dear friends, that we should use DNA. We always think that it proves guilt, but my intention to convey here is that it also helps too much in proving innocence. And I will talk about innocence project actually in US in my next slides. So this is legislation. So my another point is that DNA legislation is another important area where we should ponder. Indeed, if we see entire procedural part, whether it is Indian Evidence Act or CRPC, particularly, entire Indian Evidence Act does not find any word like DNA profile or DNA fingerprinting, right? In CRPC, only two sections, 53A and 164A. These two sections have mention of DNA in the entire gambit of CRPC, right? And that too for collection of sample. 53A talk about the sample collection from the accused, and 164A from the victim. So these are the only two areas. And now we are making DNA Act. The talk is going on. We'll talk, but this is an area where we have to look how best we can prepare our draft for legislation. I have already mentioned about DNA sampling. This is very, very important part. And I suggest, although Dr. Santi may reflect more on that, but I believe that you, because you are the scientist, so you must have some understanding of some judgments. Actually, how judiciary, particularly higher judiciary, look towards DNA. It is a very celebrated evidentiary tool, but we have to be very cautious, and the forensic scientist must understand the legal nuances. Now, let me just talk about the DNA legal framework. What are the challenges? Actually, there are so many challenges per se, and I think a lot of discussion is required, but I understand the limitation of time. But there are 2-3 very important issues. One is the privacy part, right? Then another challenge in this legal framework, who will be the custodian of DNA data? Then how the standardization of conducting DNA test. That is another very important area. The next one is whether DNA testing may be permitted in private diagnostic center or not. And there are so many associated ethical considerations. So these are various areas, or you can say challenges, which has to be dealt in DNA legal framework, which we are considering in Indian Parliament. If we see the global perspective, the US legislation is there. Nearly 60 countries have DNA legislation, separate DNA legislation. In US, these are the areas, these are the various pieces of legislation where DNA has been dealt, and they have developed so many, legal framework. But they are also encountering genetic privacy. So genetic privacy still remain the focal, point for consideration for their challenge. Another important point is the major concern for medical and other usage of DNA privacy. So these are actual challenges which even developed countries are facing, and we should take note of that. These are some issues in UK legislation, but I will not go for detailed discussion. But genetic privacy here also, it remains a challenge. Now, if we talk about DNA law in Indian scenario, because if we see what is the future of DNA, I think future of DNA is very, very, promising, undoubtedly. But there are some legal challenges, because in absence of proper DNA law, every time the accused person or the defense lawyer always talk about the limitation of DNA law in our judicial system. So I think ever since I know, since 2007, 4 or 5, draft of piece of legislation have been made, but no one could reach to the finality. That means the act could not be made so far. So many, committees have been formed. Still in the last draft that has also been discussed about 15-20 days back, and I am aware that it has again been asked to reconsider again this regulation bill 2019. The issue is that probably we are not focusing the important points, and we are actually struggling for non-important issues. You may ask that what are those non-important issues and why we are struggling. Then we can discuss it little detail sometime later. I understand the limitation here. So this is the basic structure of DNA bill. I don't think that it is required to discuss, but it has 9 chapters, 61 sections. I don't want to go in detail because I think they will redraft it again, because MHA has directed them to revisit it again. These are the highlights of 2019. Now, having said this, now I want to talk about Innocence Project. And as I mentioned in my earlier talk, when I started with Alex Jeffrey invention of this DNA technology, that Richard Pitchfork was exonerated because DNA could prove his innocence. In our Indian system, if we see, there are a lot of false allegation and wrongful conviction. It is cosmopolitan in nature. Everywhere in the globe, you find such type of problems in legal system. Then this system of Innocence Project was developed in US in 1996. One report titled "Convicted by Jury, Exonerated by Science" was released by US Department of Justice, and that has anecdotes, that has case studies of around 28 cases where the case was reached to finality and innocence was not proved, but innocent people were convicted. Because of the evidentiary strength of DNA, their innocence was proved. And there are large number of cases, say for example, Sam Shepard case of 1953, where a doctor couple was living, and one fine morning, the female or the doctor was found murdered and husband was caught. It is a story. There are so many such cases which can be dealt, and ultimately DNA later proved his innocence. So there are so many cases. If we talk about the cases of exoneration in United States, and these are the scenario till 2000, I think 19 or 20, even 20 report has also been released shortly. I don't know whether I put it in this or not. More than 150 cases are still coming, not only from other country, but United States itself. You see the developed country like US, if they commit wrongs in conviction, we consider their quality of evidence, their technology, their expertise, their neutrality in evidence collection is far better than us. Even then, they are convicting innocent people in such large number, right? And among them, 20 so far, more than 20 were on death row. That means they were innocent, but they were to be hanged, you know. So let's see the scenario in India. So my request here to you, to all the people who are basically in judicial system, whether they are lawyers, they are academicians, they are forensic scientists, they are police personnel, and the policy makers, all must consider to bring this in exoneration tool to India. And I am fortunate to tell that I got Fulbright Fellowship. I am going to US next year under Flex Award to learn the fine nuances of Innocence Project in Cornell University. My request, many of you may take up this issue, and particularly in the legal fraternity, in collaboration with institute like CCMB, that they may develop this technology in a far better manner. If you consider the director CCMB is by chance here, he may consider to introduce this thing in your school. Because if you see the legal clinics and all, I think CCMB Hyderabad, Nalsar Hyderabad is very much there. So I request to consider this type of legal clinic in their school in collaboration with CCMB. These are certain more details whereby in one case, very important case, I was associated with this case with W. Chauhan versus W. Chauhan alias Bablu versus state of NCT. The Delhi High Court basically asked them to look into these issues about malicious prosecution and wrongful conviction. This was the chance basically to our Law Commission, Indian Law Commission. But unfortunately, they just bypass it. And they said in their report, it state in report number 2277, it says that factual innocence is very difficult to prove and wrongful conviction is too high standard to address legally in India. I don't understand, my dear member of the commission, with due regard, that are we still living in very old time? We call it, we are in the 21st century. Can't our people, can't our innocent convicts are good enough, or they have the rights to prove their innocence? What is factual innocence? They are innocent. How can you say that this is too high a standard? I don't understand. As a student of law, this is my personal view. Nothing with any comment, but it pained me that at least this opportunity would have been encased, because it came through the court, and had it been dealt in a more empirical manner, probably things would have been better. And in my view, India urgently needs legal framework to address the issue of exoneration. So with this, I only tell you one more thing, if time permits, about the forensic fraud, and particularly I will give one example, citing one example from Delhi High Court, NCT Delhi versus Khurshid. In 2018, one case of POCSO where a minor girl of about 5-6 year old was raped. All medical report and other evidence were crying, indicating the indulgence in crime of the accused. But DNA report was negative. It was exonerating the accused. Considering the power of DNA, the trial court exonerated him. The state filed the appeal and it was discussed. Incidentally, In another 3 cases in the row, about in a month or maybe 2, the same bench of the court had the same type of cases. In all 3 cases, scenario is same. Girl child of 8 to 10 year, 6 to 10 year, DNA negative, but other evidence, including medical legal report, were positive. They got doubt. They sent this case for another DNA expert for reconsideration, for re-examining the DNA report. And when the new report came, it connected the accused with the crime. And more so, when other cases were also reconsidered, re-examined, the fate was same. They were actual accused. So such type of forensic frauds have been detected. In this case, the Honorable High Court Delhi requested or directed CBI to conduct inquiry, and you know the fate of such fraudster, even in the apron of forensic scientist. So with this, I just request that we should always have the accreditation system. We should always have quality control, quality assessment, so that we should not be the forensic tools, including DNA, may not be misused or abused. With this, I sincerely thank you once again, and I conclude my talk here. Thank you very much.
Thank you very much, sir, for for such a nice talk and for showing us the courtroom scenario of DNA fingerprinting. So we saw the 2 faces of the same coin. The same DNA fingerprinting can be used for proving guilty and innocence both. So really, it was a very nice talk. We'll move further to our next speaker now, Dr. KVK Shanti, who is a professor in the Nalsar University of Law, Hyderabad, and she has been teaching criminal law for 17 years. She did her doctoral thesis on penal reforms in India at Osmania University, and she is the proctor of the university and takes care of discipline on campus. She has been associated with many projects, such as study of the Indian Penal Code from gender perspective, law on grievance redressal in the public offences in AP, Transplantation of Human Organ Act in 1994, and others. She has visited Max Planck Research Institute for International Criminal Law Germany as a part of postdoctoral research program on punishment and sentencing. So with this brief introduction, I invite Dr. Shanti to inform us on the future of DNA fingerprinting technology in terms of the capacities of the DNA bill and their ethical implications. Dr. Shanti, over to you, please.
Good evening, ma'am. Very good evening to the distinguished speakers of the day. I thank Dr. Vijay Nandikuri, the director of CCMB, and I also thank Dr. Tangaraj sir for his very informative lecture. Dr. Goswami sir is done a lot of research and he has shared it with us. I have heard for the first time from him about this Innocence Project. Because I always teach criminal law and my focus is on how to get more number of convictions. And that would be the obvious temptation for a police officer. But being a police officer is thinking about thinking about wrongful convictions is a very rare phenomena in the area, in this criminal justice delivery system. So today's talk is I want to discuss the issues in the DNA bill where we need to improve slightly. So this DNA testing is currently being done on an extremely limited scale in India. Only a handful of cases we could find. With the experts are also only 30 to 40 in number. We have 15 to 18 laboratories undertaking less than 3,000 cases per year. Which represent almost not more than 2 to 3% of the total need. However, the standards of these laboratories are not monitored or regulated. So the DNA fingerprinting is already practiced in our country and the evidence has been used in many criminal courts with successes as it is already explained by my previous 2 speakers. So the procedures for crime scene collection, sample storage, chain of custody, contamination, data analysis, etc. are quite routine. And what the bill will do is ensure that they become standards for accreditation, which is of course not statutory as of now. As per the National Crime Records Bureau, there are about 40,000 unidentified bodies per year that need identification. And NCRB also reports that about 1 lakh children go missing every year across the country. So there is an urgent need to provide a framework for empowering the justice delivery system. So the bill actually sought or seeks to address concerns related to quality, accuracy, security of data and other related matters that may arise in use of DNA technology. Of course, it also, the major contribution of the DNA bill is establishment of DNA regulatory board, which will lay down guidelines, standards and procedures for establishment and functioning of such laboratories and data banks. Profiles. Yeah.
Ma'am, are you moving the slides? It's not moving here.
No, ma'am. I'm only, no, okay. Ma'am, I'm not moving.
Okay, sure. Okay, please carry on.
This one. Yeah, I'm not moving. So, as far as the law is concerned, the DNA evidence is admissible in the court of law because it is relevant, admissible, but the weightage given to this evidence is only corroborative evidence. So it is not treated as a conclusive evidence. You have one evidence which is slightly weaker, then this evidence helps to give conviction or to support the guilt of the person as a corroborative evidence. And courts consider this evidence because they have accepted that it is unbiased, it is free of fabrication and 99.9% accurate, and it also accepted the principle, all the courts including the Supreme Court, they have accepted on this principle that no two individuals will have the same DNA standard. And now, when this evidence is admissible, the major problem, the major controversy lies with the process by which the evidence is acquired. This is very important for our courts because we are into adversarial system. This is a due process model. You have to arrest the person, the accused, but the procedure has to be due. If it is an illegal arrest, then the evidence obtained from that illegal arrest will always be prone to a question. The defense counsel can always question it. So as far as the DNA bill is concerned, the major controversy is relating to data banks and their maintenance. So which data should we go for general DNA profiling where every citizen's profile would be there with the DNA bank, or should we only go for suspects and under trial prisoners and convicts? Now, this DNA bill, though it doesn't say specifically, but if you look at the long title, it says that the DNA profiling of suspects, convicts, and the DNA profiling of the crime scene index under trial prisoners is only allowed. It is not like we are creating a national data, general national data bank. But if you look at the best practices in United Kingdom, also they don't do this general profiling, but any record, a person who is involved in any recordable offense, only his profile is would be maintained in the data bank. Holland, Germany, France, or Austria, in these countries, individuals who have committed certain serious crimes like rape, extortion, dacoity, only these people who are involved in these offenses are profiled. In US, it depends upon the regulations and rules and laws of each state. So I couldn't find a uniform law, uniform practice across the countries. So in general, across the countries, the general DNA profiling is prone to, violating the right to privacy. Dr. Goswami sir has already gave an introduction about it. Dignity of the person, the right to physical and moral integrity, the right not to declare, the presumption of innocence, the right to health, the right to liberty. So these are the rights of the individuals which may come in clash with this general DNA profiling. Right to privacy, of course, as Dr. Goswami sir has already explained, is a very important right, and more so in the light of Puttaswamy's judgment. But as I have understood it, the Aadhaar card's judgment, it uses this word proportional restriction. So if you have a law and you have a set procedure, maybe this can be covered under proportional restrictions. As of now, we don't have a law. It is still in the shape and form of a bill. So maybe if you collecting a DNA profile from even a suspect or a convict also is violative of the constitutional guarantee. Now, who will, if the person, the accused, the suspect, or the convict, if he gives consent to take the blood DNA sample, there is no issue. But that consent has to be an informed consent, one. If you have, can you take the same DNA sample forcibly without his consent? That is the major controversy. In German procedural law, in Italian procedural law, in Portuguese procedural code, in all these codes, what I have observed is the judge will decide in case the person is not willing to give his DNA sample. So that is the case even in Indian courts. Dutch code also says something like this. In Indian courts also, if the person doesn't allow to take a DNA sample, the investigating officer will take the permission from the nearest judicial magistrate, and he will collect the DNA sample, and it will be stored in the lab. Now, the second problem with relating to the time period for preservation of the data which in the data banks. So, no, if I have looked at the best practices, then again, in Dutch legislation says it can be preserved for 30 years. USA says some 20-25 years. But Indian bill doesn't talk about this timeline. So how long are we going to preserve this data? So there has to be time, or there has expiry date also has to be given in this DNA bill, which is missing. Now, to what extent DNA analysis can be done of these people, suspects under trials or a convict? So I am not a technical person, but I have read few articles from which I came to know that outward things which a person can see through, of course, not with the naked eye, through the microscope only. It's called as phenotypical DNA, which is maybe also called as non-codifying DNA, which would not contain any genetic information. So it does not provide any data on medical problems. His personal sensitive data is not touched upon. So this kind of analysis may be carried out in either consent cases where consent is given, or in cases where consent is not given. The criteria, and then you can also have a catalog of crimes which is again missing in our DNA bill. In the rest of the countries, what they have done is this is allowed only in serious crimes like rape, murder, dacoity, extortion. But we haven't given any such kind of specification in our DNA bill. Maybe this is also one of the lapses or gaps which can be filled. This forced sampling, 53A of CRPC 53. Whether can we take forcibly the sample from the person? If you take forcibly the sample of DNA, whether it comes in clash with Article 23, Doctrine Against Self-Incrimination. I want to draw the attention of the distinguished speakers of this webinar today towards this judgment given by Supreme Court of India in State of Bombay versus Kathi Kalu in 1961. What they have said is, if you this specimen handwriting, signatures, impressions of thumb, finger, palm, or foot, whether if these things can be, if they are taken forcibly, does it amount to violation of Article 20, Clause 3? What they have said is no, because to be a witness means you have to make a statement. The person has to make a statement using his mind or brain or faculty. Only those things are, then only it is called as to be a witness. These, fingerprints, saliva, DNA, sperm, or what hair strands, they are called as material witnesses, so that there is no compulsion that, or this Article 23, this guarantee is not given, or it is doesn't cover this kind of getting this kind of material evidences. And let me tell you, the Voghart's case, I think that would be that can be considered as a parent curium. Very recently in 2018, in this case Halappa versus State of Karnataka, it was again held that collection of blood sample for DNA forcibly without the consent of the accused is not violation of Article 20 subclause 3. The AP Shah committee's report was referred to by my previous respected previous speaker. So they have made certain suggestions to be made in the DNA bill. Some of them I have put up on this slide here, that they should be stated.
Shanti, you are in the very first slide. Your slides have not moved.
Oh, not moving, sir?
Yeah. You are in which slide now?
I'm in the almost like I have come to the 13th slide, sir.
Okay. Click on that. Yes.
I don't know why. Yeah. 1 second, sir. I'll try again then.
Yeah, no problem. You can continue moving now.
Okay, sir. Then
we are also not seeing the full screen. Maybe you can escape and.
I have escaped, sir. I've brought it into the normal view also.
Okay, then you can move on after that.
Oh. So there have to be safeguards to prevent illegal collection and use of DNA data. Provide safeguards to prevent the proposed body, the DNA banks and the DNA authorities for misusing the same. This is one thing, a very important point, that there has to be mechanism using which citizens can appeal against the retention of data. And the bill allowed volunteers to give samples, but there is no proper procedure to obtain consent. And there was no mechanism under which volunteer can withdraw his data. So these are some of the doubts which were raised by the AP Shah's committee. This is my last slide, sir. So I'm trying to sum up some of the gaps which I have found out in my research in the DNA bill. The first thing is the crime scene index. In the crime scene, not only the fingerprints or DNA of the accused would be there, but some other person's DNA also would be there. So when you profile a person who is not involved in the crime, that person doesn't even know that his DNA sample is lying with a CFSL or some central forensic lab. If that is misused, what is the how do we protect that person? Where is the guarantee that DNA sample, if somebody can drop it in some other scene and may implicate him in that crime? Where actually he is an innocent person. So this is prone to misuse. So this is one thing which need to be taken care of. Section 30 of the DNA bill says, upon the application of the person, that his data can be removed by the data bank. But how, if he doesn't know that his profile is lying with them, how can we expect him to make an application? So I think that has to be done by the data bank themselves suo moto. And then we have to have a timeline for sample deletion from the data bank. The Rajya Sabha committee under the chairmanship of Dr. Jairam Ramesh, they have suggested that we will not have regional data banks, where DNA bill talks about national data bank, central data bank and also regional data bank. So they have renamed this central data bank as national data bank, and they said that regional data banks are not necessary. That is their suggestion. So some of the apprehensions are there, but they are apprehensions only. There is no evidence for these apprehensions that if you go for a national data bank, that DNA profile may be misused, the data may be misused. So one of the MP member of parliament, Mr. Asaduddin Owaisi, also has raised this concern in the parliament, but he did not appear for reasons best known to him before the Rajya Sabha committee. There is no written statement given by him. He just made a statement that he has an apprehension that this data can be used by the governments for the persecution of minorities. So the same apprehension, no, we have heard in US also that it could be used for racial profiling, to torture and to, to corner the blacks there in that country. At what stage, the next question is, at what stage DNA sample has to be taken? It is advisable to take it at the investigation stage itself, but not beyond that. And lastly, and very importantly, we are very soon going to have a data protection bill, which has the Sri Krishna Committee report also says the same thing, and on the basis of Sri Krishna Committee report only the present PDP bill has been made here. If this law comes into force, this data will come under sensitive personal data. So it is again protected under PDP Act. Then you will have a great clash in between this DNA profiling and those provisions of that bill. So I think first, if we can have the data protection bill in place, and then after that, if you can have this bill, maybe you can avoid that clash. Another important gap which I found in this DNA bill is it is silent about civil cases where generally the parent's identity is in question. There is no specific provision to this effect. Lastly, this gives this DNA bill gives an opportunity to have private labs also. They can be accredited, they can be licenses can be given, and then normally the prosecutor will get a report from CFSLs, Central Forensic Labs or government labs. So Defense Counsel then will get an opportunity if they don't have, if they have some suspicion about these reports given by government labs, they can go to private labs. But then in the course, we may have clashes in between the reports given by those private labs and these government labs. In my conversation with some of the scientists who are working in the CFSLs Hyderabad and also CFSL Punjab, they were very much against this provision. They said that it would undermine the integrity and commitment of the scientists working in these labs. So these are some of the important points I wanted to share. I'm really privileged to be a part of this August gathering. Though I strictly don't deserve to be here, I thank you very much for your patient hearing. I thank everyone who are present here in this webinar.
Thank you very much, ma'am, for your talk and really giving an overview of the ethical and other issues related with this DNA bill, and also summarizing the gaps of this bill. So, yeah, we have few questions from the audience. We'll take up those questions. So, first of all, question from Komu Nagayaji. Is there any study on rare disease like sickle cell anemia, etc., or a study on genetic data on tribals has been done or going on at CCMB or the other lab?
Can I answer to the question?
Please, sir. Please.
Yeah, in fact, so both of the things are going on in CCMB as well as in many other CSIR laboratory. The first question about sickle cell, yes, we have a big program. So one of my colleagues, Dr. Chandek and IGIB are having a big project on sickle cell. And regarding rare disease, yes, there are several projects, several organizations, including ICMR, DBT, are now funding for rare disease, and even Ministry of Health and Family Welfare. So they are come to a stage where they wanted to even treat the patients with rare disease by getting money from different sources. So they have about 10 institutes which have been registered under that. Through those, the rare disease will be treated.
Okay, thank you very much, sir. Another question is to Dr. Goswami from Achin Jana. He wants to know how, according to you, the post-conviction DNA test can be conducted under the present Indian legal scheme. Can an accused ask for DNA test in India?
This is a very interesting question. indeed, if you go by the strict sense of law, so as I told, 53A of CRPC only talk about collecting DNA, or you can say blood sample from accused of rape, but we are using it. So that is one thing which defense lawyer always talk about. Now question arises, if he refuse, in case of sexual offense, he cannot, because it give you overriding effect, right? But in other case, say for example, other body offense or other even the property offense. These days DNA profile is being used even in property offense also, right? So there the law is silent. Okay. So again, I always say for this question that best legal remedy is that please go to court, ask the court and request them to get an order rather than forcibly collecting the blood sample by police. I don't agree to it. So this is one remedy. As far as the DNA sampling for civil matters is concerned, this earlier I was talking about the criminal matters. Say for example, for paternity disputes, if you go to Gautam Kundu case, very celebrated case of 1993 of the Apex Court, it's fifth. They have 5 guidelines actually where DNA should be conducted. So the 5th guideline says that nobody should be forced. It should not be coercive. But on the contrary, if you see ND Tiwari case, the same paternity determination, the court said and directed the district judge of Dehradun that even if you require force to collect blood sample from ND Tiwari, please do it. So there are so many contradictions. Okay. Now further, if suppose a person does not give sample, say even in civil disputes, so what is the remedy? The remedy is there in the law. It is the section 114 of Indian Evidence Act. Say it is adverse presumption. You may take adverse presumption, but in my view, adverse presumption is more ethical for going to civil disputes. As far as about crime is concerned, because you have to prove beyond reasonable doubt, hence you cannot take and go by adverse presumption. You have to be either right or left. You cannot be in between. You have to prove the crime beyond reasonable doubt. It is not preponderance of probabilities. So I think if in crime you want to take sample, better to get court order. I think ma'am, Professor from Nalsar will agree to me to the limited knowledge of mine.
No, sir. So, yes, sir. Yes, sir. But your knowledge is not limited, sir. It's unlimited.
No, ma'am. Thank you.
Can we move to the next question, sir? Yeah. Can any person or public or a detective agency order for DNA fingerprinting test on their own? Or they require legal permission? So basically, they require legal permission.
Yeah.
Yes.
Yeah. So always.
And one thing I want to tell, unfortunately, and I think ma'am will again say something on that. I always believe that for proving innocence, an accused should also be given right. Why if I feel that I am innocent, why should my request should not be attended, that I say that please conduct my DNA? Why IO should always be given preference? So if it is exculpatory evidence, why you are avoiding? So I think even accused should also be given right to undergo forensic testing. So this right should be emerged, I think, with due course of time. This may be the next course of action.
Okay, thank you. So next question comes to again, when high sensitive DNA techniques are used, very real possibility exists for contamination of DNA coming from someone else associated with the case. So in that, what will be the next step in the crime investigation in this kind of issues? Contamination of samples.
If there is any contamination, by using, now the techniques have changed, right? So now we use probe which look for a specific region, so a single locus, If you are using one individual's DNA for making profile for every locus, for example, now we use single locus maybe 10, 20. So for every locus, we should get only 2 bands, right? Or maybe 1 band if it is homozygous. But if there is more than one, then accordingly the number of band for particular locus will increase, right? So that itself says that there is a contamination. Then due course of action is up to the investigating agencies how they deal with that.
Okay, thank you very much, sir. So one question is regarding CCMB's work. It's not related to this. The viewer wants to know the progress in CCMB and how the spike protein chemical structure transformation differ from COVID-19 virus. So if Dr. Thangaraj can put some point in this, or otherwise we'll move ahead.
No, I don't have any idea right now what is going on. But maybe.
Yeah, okay, sir. So we'll move to further the question. So how can we get the slides? So slides, actually, these are these talks and webinars are always available in the YouTube, Twitter, and Facebook channels. So slides can be available like in the presentation that's going on through the webinar. People can have a look here once again. So we are at the end of the webinar as of now. We don't have any further questions from the viewers. So yeah. So we'll move further. So since the director CCMB has left for some urgent meeting, I request Dr. Thangaraj to kindly deliver the closing remarks for the session. Sir, please.
Okay. Thank you, Dr. Shika, for organizing this event. And so now there are many things, legal aspects are even new to me, which I came to know through Dr. Goswami and Dr. Shanti. I'm sure that the viewers who are of with a different background would have got sense of the technology, how it is being used, and what is its future. Before concluding, I just wanted to look at how we have delivered the lecture and what are some points to be discussed. Dr. Goswami, he rightly highlighted about the legal aspects of the DNA fingerprinting technology. And so what he was mentioning about the legal and challenging aspects are really very important. But the privacy, when he talks about, anyway, I'll come that aspect a little later about the privacy, because Dr. Shanti also talked about it. He also mentioned about the Innocent project. That's very, very important. That I think there's a saying that the innocent should not be punished, even, right, for any cause. So that is very, very important point to be discussed. It's not the right forum that we can only discuss, but it has to be taken in a forum where there should be some kind of solution for that. Okay. And I thought of mentioning about this code system when we talk about the Innocent project, also about the DNA bill, right? So there, the code system, that's a combined DNA index system, which has been used worldwide, have set up the server. One of the important aspect of that is that the individuals who involved in crime anywhere in the world, and somebody did some kind of crime India today, and they moved to some other country, and that's a different kind of crime. So he can be actually, he or she can be tracked and traced, and precisely can be identified. So that's one of the important system, but I don't know if the public knows about it. But but very important thing to understand. Then Shanti was talking about there are about 40,000 body which has not been identified, about 1 lakh missing children whose identity has not been done. But this is possible to do. The cost involvement per sample is not very high. So 2,000 to 3,000 rupees one can able to identify. But other aspect is that making profile of those individuals is not a big issue, but the people have to come forward and say that so they have lost their children. So the parents' DNA is very important. Unless otherwise somebody come forward to say that so they have missed their child or children, very difficult. So that is another important point one should keep it in mind. When we talk about, I think Dr. Shanti talked a lot about a DNA bill, but now the DNA bill has been redrafted, not totally. There's a parliamentary committee which looked at it, and they have given large number of questions to DBT, and recently we had a couple of meetings. I don't want to tell in detail about that, but all have been very, very precisely asked question, and so we have replied again precisely that whether we accept, not accept. If you are not accepting, what is the reason for not accepting? So it went on to that detail for that particular bill. I hope that it would come very soon to Parliament for the discussion. Some aspect which you mentioned is about whether the DNA profiling is going to be conducted for all the individuals or only the suspect or only the convict. Yes, it's not for everybody. It's only for those suspect, convict. And also there's a timeline that if it is not proven, the suspects is not proven to be involved in the crime, and the profile will be destroyed from the database. It will not be kept, and it will be kept until the crime is solved. Okay, so there's a lot more into that, but I don't want to go into detail of that. And when talk about right to privacy, you also mentioned that you read that it's not used for any medical application or something else. It is indeed correct, because the profile which we use is not for the entire DNA or genome. So we look for a place where there's more variations existing. Those are the place that's very, very small region of the total DNA, very, very negligible, which gives information about whether the person has 10 repeat or 9 repeat or 8 repeat, nothing else. So I mentioned that GATA repeat. Okay, so that repeat is 10 or 9 or 11. So that vary from chromosome to chromosome. So it's not going to give any characteristic feature of the individual. It's not going to give whether the person came from this background or that background or this religion or that religion. It's nothing. Okay, for that we use a different set of markers. Okay, those are highly conserved, and for our study to trace the human origin evolution are the one which we use. For DNA profiling, we use only the region which shows highly variations called as polymorphs. It will not give any information about the individual except for the identity, uniqueness of the individual. So therefore, nothing to worry about that. Then about database, and also you talked about MP Mr. Voici. I also seen several pages of his letter. Mostly was talking about this aspect. but that even the committee has taken it that differently, answered that, and DBT also answered very rightly for that particular aspect. So overall, it's a very useful, pleasant afternoon for us, and also for the viewers, I believe. And we have very limitation time, but this is what we could do with the limited time. I hope that you all will agree that if any of the viewers want to get more detail about that, I am available. I hope that you are also available to get a little more information about whatever they want. And so I think that's what I wanted to say, and I wish to conclude this by thanking Dr. Shika, Dr. Goswami, Dr. Shanti, and Dr. Vinay for this wonderful discussion on DNA fingerprinting. I also thank CCMB and also CSIR for bringing this. Right? Without that, it would not have come to the public. Yeah. So with that, I conclude my very brief discussion. Thank you very much.
Thank you very much, sir, for closing remarks and summarizing the session. So it's definitely a great effort from both Team CSCMB and Team CSIR headquarters. So thank you everyone for making time and joining with us. And our viewers, special thanks to each one of you for connecting with us and interacting with the speakers. So our next reporting will be another interesting success story from CSIR next week. Stay tuned for the upcoming session.
I'm curious to know how many viewers are there, because I couldn't see the number in the participant list also.
Ma'am, we will forward you the viewers list. As of now, even I am not able to see. Okay. I am also in the, yeah, we'll send the participation list. So thank you very much for connecting.
Thank you.